As we bring the needle back onto the page in tonight's edition of the Capitalk Forum, we delve even deeper into issues of deceased estates. Zvinombonzi hanzi pane mumwe muimba akaimba kuti hanzi pfuma yanhaka inoparadza ukama. We want to get to a place where we understand the laws around this very emotional and difficult time, but it also asserts rights. Iripo mtemo inototaura maererano nekuti zvinofambiswa sei. So we want to just revisit that. Kune vanenge vakapotsana nechirongwa last week. You're so lucky we're doing it again this week and deep diving. My guest is Kudakwashe Masiye Nyama. He is an attorney with Chikwangwani Tapi Attorneys. Good evening, Kuda, and welcome.
Good evening, Rumbie, and good evening to our listeners.
Wonderful, as always, to have you on the program. So, Kuda, you did such a good job last week or the week before of delving into these issues. So much so that by popular demand, so I think, we give the people what they want. So here we are delving into this issue once more. Part 2 of this discussion. So just as a way of recapping, Kuda, what happens to someone's property, to their assets, immovable or otherwise, when that person dies without leaving a valid will?
Okay, thank you, Rumbie. So we say that when a person dies without leaving a valid will, their property or assets will have to be distributed in what we term at law, what we call under the law of succession, the gift or registration or distribution of deceased estates. And so there is a legal way in which people can inherit from the assets and or the estate of a person who would have deceased without leaving a will. The law gives us a guide and some mandatory guidelines of who can benefit, who should benefit, who may benefit, and who cannot benefit in the event of a person dying without leaving a will. So this is what we were talking about, to say when you die without leaving a will, and there are assets that you would have accumulated or properties, to say in clearer terms, those assets or those properties at law, it's not allowed to just distribute them or to just say ndini baba wake kana ndini mukuru wake kana ndini mukoma mukuru, so I'm taking over everything. The law criminalizes that. It's not allowed. It has to go through the legal process of estate registration and then the distribution of those estates according to law.
Kuda, just as you're saying that, let's walk through what should happen when someone dies. You're talking about the legal processes that are attached. Say, what does the law prescribe, or what are the steps to take upon someone's death?
All right, let me start by differentiating that people who would have died, or at least they are governed in terms of the general law, or basically, or easily to say, those who are married in terms of marriage act, general, right? And those who are governed by general law, the estate of such a person who would have deceased while at least being governed by general law is determined or is done through the Deceased Estate Succession Act. And in terms of this act, what it says is that the surviving spouse, if you die and then you leave a surviving spouse, here we don't talk about spouses, because this is the general law says one husband, one wife. So there is a spouse that we'll be talking about. So according to this, the surviving spouse is entitled to receive from the estate as his or her sole property, the household goods, the effects of such estate, and a child's share property together with what we call the matrimonial home. So there is a categorization of what will automatically go to the surviving spouse. Okay, that is in terms of the general law, right? And then the residue, what will remain. Remember, I have said there is what we call a child's share. What will be remaining then will be shared by the children of the deceased in equal share, whether or not those children were born in or out of wedlock. So this is number one. But if the deceased is governed or was under what we call the unregistered customer law union or under customer law, then it's a bit different because there is a potential polygamous marriage which will be there. So under this one, the surviving spouse received the immovable property in which they were living in immediately before the death of the deceased. And 1/3 of the net estate goes to the surviving spouse. So we remove now. We are saying the house in which they were calling the matrimonial house that they were living together with the deceased, that automatically goes to the surviving spouse. And 1/3 of the net estate goes to the surviving spouse. The remaining then goes to the children in equal share. If there are no children, it then goes to other family members, the parents, if no parents, brothers, sisters, and we go like that. This is how, basically, or in short, it is done. So in the event that there are 2 or more wives, right?
Let's go there. Toti pana mai guru na mai nini. Vari kugara kwakasiyana. I think in the first instance, zvofambiswa say, then in an instance where there is 2 or 3 mai guru na mai nini vadiki who are living on the same property.
Okay. So if we have got two or more wives or spouse living under the same property, they will share that property in equal share, that because it will form their matrimonial property, right? But in essence, in terms of the whole estate, what we'll be saying is that the 3 of them will be entitled to 1/3 of the net estate. So it's shared between or amongst themselves. 1/3 goes to them. But this is where we were saying that the first wife is entitled to 2/3 of that 1/3. Well, so one at the lion's share of the 1/3 that they are entitled to. And then the second wife will be then entitled to the other 1/3 of the 1/3 of the net estate. So if the wives were living in separate houses, there is that deceased, right? Then each will be entitled to the property angar kugara. So it doesn't matter kuti pamwe mainini ndo anga ari kugara kuborodhi. Maiguru achigara kuti vachigara ku airport kana kuti.
Because nyayema values comes into play. So if my guru was living in a house that's less valuable, vanotora iyoyo. What happens to that lion share aspect?
No. Remember, we are saying kuti we are going in stages. We say we take the lion's share, we take the matrimonial home. The matrimonial home at we determine who is entitled. They take equal share. Each anotora kwanga kugara. Then we go to the net value of the estate, and then that's the 1/3 that they will have to share. Wherein of that 1/3, the 2/3 will go to the first one.
Okay, another sticky wicket that I want us to look at. Patinotaura kuti vana or the children of the deceased Is age a factor? Kuti pamwe kune vamwe vana vari under the age of 18 vaya vatinoti ma-minors. Koti koitawo vana pamwe vari ma-30, 40 vatorino vana vavo. How does the law look at it? Pofa musharikwa ofa asina will asi ane vana vati kurei nevana vadiki pamashares avapa. How is it done?
We have to look into the minor children. Yes. So it is very possible for the minor children to benefit, while at least those who would be major may not benefit, depending on the size. But definitely priority is given to minor children.
Saka zviya zvekuti, all right, in other words, I really want to make this as plain as possible. Toti pana Rumbie ari 34 handiti, and then there's Zoe who's 2, and then there's someone else who's 16. Can Rumbie be disinherited? Or can Rumbie be left out of the bracket? Zvichipiwa Zoe neumwe mudiki. Is that how the law would work, since you're saying there's preference for the minor children?
Yes, the minor children will have to benefit best.
Hazvina discrimination here izvozvo mukati, handitese tiri vana.
But we are saying kuti one is a minor, meaning to say they still have a lot to go through in order to survive, in order to get to the stage yasvikwa Rumbie, who is now an adult. Akwanisa kuzvimhanyiro achinotsvaga mari, but mwana akaenda kuchikoro, mwana aruda hembe dzokupfeka, mwana we shouldn't, the law will not be serving its purpose if it ignores the need or the needs of such minor children.
Now, we want to move into what happens when somebody has a will, but before we do that, another aspect that seems to always be quite problematic. Mambotaura imimi kuti zvevaya vanongouya voti ndezvamukoma vangu, ndezvehanzvadzi yangu, or ndezve ningi wedu, baba mukuru wedu, and etc. These people who just pop out of nowhere when someone dies and they want to take things. How do you deal with that sort of thing? And what does the law provide for?
The law actually criminalizes such acts. It's not allowed for people on their own without registering the estate to dissolve or to distribute or grab my property, including even marrying a bank. It's not allowed. If that happens and then a report is made, it will cause somebody to be arrested and liable for criminal prosecution. So every estate must be distributed according to the law.
And just for avoidance of doubt, that requires registration. Tirikuti kana muri mukuchema menyu, we know it's a difficult time when someone passes, a spouse or somebody very close to you, but you've got a requirement and an obligation to actually, within 14 days of this death, to go and register that estate, to be able kuti mubatsirwe kukazvita zveproperty grabbing, as Kuda is saying there, munenge mune kwekutizira. Sazviya zvekuti aiwa ndipe maki yemota, ndipe bank card, ndipe chakati, hanzi hazvipo pamutemo. And so let's talk a little bit about how can, particularly vari a little vulnerable, widows and so on, unofaita sei vana baba mukuru vari kuti titoti pamaki yemota izvezvi?
No, it's simple. One of the ways to do that is to in estate planning. One of the things that is important is to keep your lawyer. So you can invite your lawyer, and the lawyer can simply come and advise of the position of the law, and tell people, okay, guys, the only thing that you can distribute here, until the due process of the law is followed. It is also important for people to be educated to know that, because especially if it's a man who would have died, vanhu vanopindwa nepfungwa yekuti mukadzi zvemulin'ina wedu mukoma wedu obva atotiza nazoenda kunoroorwa nemumwe murume ozodii zvinhu zvehama yedu zvoparadzwa. Even mukadzi wacho anenge asingatenderwewo nemutemo to just do as zvaafunga as she will be required by the law to also follow the due process of the law. And in following the due process of the law, those relatives will be invited for what you call edit meetings. If you go to the master of the High Court, which is the office in which all these deceased estates are now being handled, you will definitely then have to be required as of law to invite, to advertise the estate in the newspaper and everything. So no one will be jumped, no one will be skipped. You will still be entitled to go for the meeting, have your issues to be heard, and have your rights protected. But it's now a question which was really would the law actually give proper and due protection to everybody. And panotoitwa ma-acts twice actually, and before all that. So the real problem is that people will be thinking that tikabva panapa tisina kutotora mamota todzisa pakanaka todii kana kuti tagreba, then that's the end of the road. But that's not what the law says. The law has in a very proper way and wants it to be done in a legally acceptable way. So people can utilize that route where you can have your lawyer coming through and advise. We do have lawyers for human rights, lawyers on women's rights, and whatever. You can advise them. I'm having a situation like this. I don't think I'll be able to contain my relative. The property. I need someone who can advise people properly. You can as well also utilize the services of the police to say if you think you will be that much vulnerable. And the most important thing is that we encourage people. Last time we were talking about this estate planning. In order. Talk to your relatives, talk to your brothers and sisters, to your parents, to everybody. Let them know, even if you die without a wish, but let them know, because so you have to let people know, no, guys, this will be done this way, this will be done this way. Of course, the most appropriate thing will be to put your property, to have a valid will, or at least to put your property in family trust and what have you. That's better estate planning. But the ball comes back to say, to what extent have we really done our estate planning in a proper way?
You bring about a very important aspect now, Nyayema valid wills. What makes a will valid? And what recommendations can you give to our listeners around how they should start the will writing process?
Okay, thank you about that, Rumbie. Last time I mentioned that the word go, I said sometimes it's tricky for individuals to properly draft legal documents, and I recommended that if you want your will to be done, you have to. It's wisdom to look for legal counsel and be guided by your lawyer drafting the will. That's one of the most important things. But when we are saying a will, we are saying in simple terms. Rumbie, before while you are in your sober and sound mind, without undue pressure being exerted on you, without you fearing that I'm about to die, you sit down and say, I want to determine how my property is going to be inherited when I am deceased. So a will have to be written by a person who is in their sound mind. That's number one. A will have on the part of the person with the writing the will. The will must contain the name, the full names, surnames appearing on your ID of the person who is attesting or who is writing the will, right? And a will must be signed by that person and must have witnesses who are in themselves adults of a sound mind, who are at law able or capable of freely contracting or entering into a valid contract, should I say. And okay, what else can I talk about? Then it has to be dated. A will that is not dated will be automatically invalid. It has to be dated. And then you have to also make sure that those who will be witnesses to your will not be beneficiaries to that will at the same time.
And I think another aspect, Kudade, just to add in, aspects of ndikanyora will yangu ndichiri jaya kana uti ndisati ndawanikwa ndozowanikwa, that first will becomes invalid, isn't it?
Indeed, yeah. So you have to update your will. Actually, it's important to do that because you can. Another aspect is that you can also write. I can write a will that, my car, like what I said last time, that my GD6 will go to Rumbie, and then Rumbie over and Tangira Gufa,
Yeah.
It follows.
Saka zvinoda kutofunga.
Exactly.
Yeah. And I think another aspect as well, Kuda, that we can also talk about, choosing your executor. What's the importance of this role, and how does it come into the will writing process?
That one is a real issue because it's one of the areas in which my wills are challenged nowadays, in our time. Basically, nyaya yekutendeka chaiyo ndo dambudziko ratinaro, whereby you put in somebody as an executor, and that somebody who then wants to what should I say, to arm twist or change things for and follow a different route other than that which is contained in the will. So it is very important when you are choosing the executor to know that you are choosing somebody whom you know in terms of their integrity, in terms of your relationship, in terms of also that they will save your interest at the end of the day.
So many things for you to consider. There's Kuda says Gudanzi nyasai kuona mna anotendeka wekuti anoita zvamataura, because remember you won't be around to enforce. Even the threat of you taking action is no longer there. So it's important that you really pick the right person. When in doubt, pick a lawyer, did you?
Indeed, that's the best.
Yeah. And it's not for biased reasons. That we're both lawyers. Not at all. It's the right thing to do. It's the right thing to do.
Somebody, I told somebody about that, and then they said, but lawyers, you are actually on the forefront of changing things and confusing the whole families. Actually, somebody was giving me a lot of examples where he was saying, I have this example, and this example. At the end of the day, it was a lawyer who ended up being the secretary.
Yeah, but even then, even if that happens, you can actually apply to have the executor removed if you're not happy.
Sure.
Absolutely. Could I want us to jump into some of the questions that we're getting from our listeners before you tell us, some of those good tips on estate planning? This one is from Raymond, who says, "Hi Rumbie, what about if the senior person is the one who helped to build the house for parents?" So I think they're trying to say, "Kuti panenge pane vana handiti mwana mukuru obatsira kuvaka imba yevabereki handiti then mubereki ofa kana kuti vabereki vofa, he's asking kuti does that older child or that senior person in a family benefit to the extent or to the level of their contribution, kuti ndini ndakabatsira kuvaka imba saka ndofanira kutowana the lion's share patinoita distribution of property, ndizvo here? How are those cases dealt with?
No, hazvadi zvidaro. Pawaibatsira vabereki, you're not helping yourself, you're helping the parents. So it does not follow that it becomes yours. Your donation was a very good donation, but it does not give you any advantage over others. It doesn't work that way. Remember the property law in Zimbabwe, especially when you are talking about movable property, that the land, the person who owns the land owns the building.
Yeah.
Any erection on that land, it's presumed that the owner of the land is also the owner
of the buildings. Yeah. And any improvements.
So your parents, it remains 100% property. I do have an example of something that I also encountered whereby the father died, but what he had done is that he had put a certain property in the name of his wife in 50% share and the other 50% to his only son. And the elder sister now came and developed the property, and it's in waterfalls, developed it, erected very beautiful up buildings and all that stuff. And then the son came in and said, now can I have my 50% of the share value? So there was a dispute to say, but you did not contribute anything. But he was saying, no, I'm entitled to my share.
Yeah.
And there was that. But the bottom line is that no, it will not give you any added advantage because it remains the property of the deceased who will be your parent.
My donation chingopai without expectation.
Without expectation.
Absolutely. There's this one is okay. This listener asks 3 questions. All right. So they say anzi konai kana kuri kumusha kunotongwa nemadzishe zvema last wills and testaments zvinoshanda here. They go on to ask whether the master of the high court has jurisdiction mudunhu ramambo. And then the third question is, if I take on dual citizenship, does it invalidate my will? So I think those 2 questions, pakutanga anenge akada kubatana kuti jurisdiction kana tichidhila nemunhu anenge ari kumusha hanzi inoshandwa nayo sei, wiri inobudiswa yoverengwa nachief here, or you still go and register kuna master of the high court. Zvine kakusangana kazvinoita here apa kuda?
Okay, the will still have to be registered in master of the high court. Remember, we are saying for it to be valid, it has to be registered as well. If it's not registered, it's considered to be a person who did the valid will. So you have to register it. So that's how it works. But I also thought the listener's question is also going beyond the question of wills and asking about how these estates are dealt with, Mamisha, the distribution and the like, without following this process we are talking about. But I would wish to restate that the jurisdiction of the local courts, local and community courts, does not extend to distribution of deceased estates. They can entertain the issue of disputes which would arisen, the issue of but they don't have the jurisdiction to distribute a deceased estate. The office that is reposed with that obligation is the master of the high court. No matter where you are in the whole country, you have to follow that legal process.
Very succinct. Thanks for that, Kuda. This one is from Gina, who says, Okay, so they're asking about recent developments. They make reference to the recent regulations by the Judicial Service Commission requiring that there be a certificate issued by the Master of the High Court in the case of remarrying and so on. So they say, why does So they say, why does the Master not ensure that vabereki vemufi are present even when the deceased anim chato? I have a case here, ex-wife vemufi went nevana vake and registered the estate with one brother excluding vabereki. Anzi panofambiswa say if other people are excluded in the registration process.
Okay, they still have the right to challenge the whole process. But maybe people need to understand this, that what happens is if a person dies, there is the issuance of a death certificate. If you take the death certificate, the person who will be holding the death certificate, maybe the surviving spouse, together with the children or the children alone, they can approach the office of the master with the death notice and what is due, and then they can start the process. Then there is an invitation, that was the one which I was saying, for the meeting, for them to bring relatives of the deceased for purposes of appointing executors and beginning the process and what is due. So it still can be that if people want to be trickery in a way, they only take those people whom they know will support us. And once it appears, if those are the only relatives or relevant relatives of the deceased, you understand? But the law then comes in to protect, because remember we said the first thing that happens is that there is an advert that is put in the local newspaper notifying the public that the estate of so and so, late estate of so and so is now being registered. Those who would want to come with objections, with creditors, debtors, are invited, and everybody who may be an interested part will then be invited. Now, this is where the compulsory part of it comes in, to say those who would have been left out will have a chance to come. Number two, those records will be open for inspection at the office of the master. Anyone can go there and say, I want to inquire about the estate of late of so and so who died at such a time. And then those records are readily available, can be shown, and then you will see that there are people who have made some moves towards the registration in what is due. Mm-hmm. But in the event you put all that jumps and you will still be entitled to approach.
Pamwe andiverengi newspaper ka saka ndobva ndatadza kuona notice yacho.
Yeah, it so happens. But when it's fundamental, and for instance, you are actually really entitled. You can approach the court and inform them that I was not included, and there was probably deliberately leaving me out because people knew of my existence, and then I want these things to be reviewed, and then a review can be made, and then you be added.
I see. And if properties have been sold and so on, I suppose if they have not been transferred, then you'd have, or even if they have been transferred, you can actually still cite these parties in the High Court. All right.
Indeed, you can, especially if the affected person is a minor. Even if the property has been sold to a third party, there is still room for a review to be made, and then for
the decision to be set aside. Wonderful. There's one last question here: dual citizenship. Does it affect your will? I mean, if I'm a citizen of Zimbabwe and the UK, ndigaita will yangu Zimbabwe ndova ndaita dual citizenship, does it invalidate my will?
I wouldn't think so. Of course, I would like to, because they just mentioned the issue of dual citizenship. I would like to think probably challenges would come if you would have renounced
I see. So maybe I think that was the input of the question. But as of Funzane side, so if you renounce your citizenship, that could invalidate your will then.
I would like to think it's not automatic to invalidate, because the fact that you are not a citizen of the country does not affect your property ownership rights.
This is true. This is true.
Property.
Absolutely.
Yeah.
Kuda, we've fast run out of time. As quickly as you can, your parting shot to all the listeners on this very important subject. Tatwasiya zvimwe kuna mwangashida kuzioti kuita wiwi yacho kunoita mari and so on. But we're going to the news now. Very quickly, a parting shot, Kuda.
Yeah, go do your estate planning while you are alive. Yeah, there is good time. Consult your legal practitioners, your lawyers of choice. Come to our offices to assist you, and do it while at least you are still alive, so that you don't leave problems with your children and your spouse.
Wonderful stuff. Very well put. Thanks so much, Kuda. We'll connect with you again next week to discuss more legal matters and separate fact from fiction. Good night. The time is 7 o'clock. It's time for the news.